Assalamualaikum and good morning, good evening, good night to my lovely panel. My name is Muhammad Iradi bin Khalid. I am a bachelor in law student, law and commerce student, and today I will presenting my legal research. So the topic for my legal research is justice in Malaysia. Is rule of law applied to the executive branch? First, I will talk about the abstract, which is in this study, it is focusing mainly on analyzing the justice in Malaysia, where the politicians in this country act as if they are invulnerable to the law and above the law. This study also to find out where the problems or weaknesses of the national judiciary and the constitution that have led to this problem. Nowadays in Malaysia, there are many news or cases where politicians in this country are easily getting away from their legal offense. So summary of the methodology that have been used in the study are from data analysis procedure and from data collecting, interviewing random people. So the research question in this research are whether the legal system in this country are weak, are the politicians in this country are abusing their power for their own benefit. So finding this research in this research is that in this country, it is clearly stated in the constitution that no one is above or invulnerable to the law. Though it is clearly stated that the actual problem and weaknesses are the people in Malaysia, national judiciary, and the constitution that led to the result of many cases of where politicians are getting away from getting legal action. So conclusion, the study will help us to understand more about the justice in Malaysia and to find where are the problems that led to this issue. Introduction. So the research is the justice in Malaysia, rule of law applied to the executive branch. So the main purpose of this study is to know the validity towards the matter of this problem. There are many cases and news in Malaysia where the politicians abuse their power and break the law, and it can be seen clearly that they are guilty, but they are not getting legal charge. Even if they are getting legal charge, it seems that the punishment that they get is only the minimum punishment of the offense, while if a normal citizen is otherwise. According to the Federal Constitution of Malaysia, Article 8 of the Constitution stated that all persons are equal before the law and entitled to the equal protection of the law, except as expressly authorized by this Constitution. There shall be no discrimination against citizens on the ground only of religion, race, decent place of birth or gender in any law or in the appointment to any office or employment under a public authority or in the administration of any law relating to acquisition, holding or disposition property or the establishing or carrying on of any trade, business, profession, vocation or employment. There shall be no discrimination in favor of any person on the ground that he is a subject of the ruler of any state. This research also refer to the politicians in this country or the party politics party politics in this country has abused their power by interfering in the legal system. Malaysia is a country that adapt the separation of power, which is separation of power therefore refers to the division of government responsibilities into distinct branches to limit any one branch from exercising the core function of another, which is judicial, executive, and legislative. The intent is to prevent the concentration of power or abuse of power and provide for checks and balance. Now I will talk about the background of the study. So Malaysia practice parliamentary democracy, which with constitutional monarchy. His Majesty the King is the head of state. Parliament is the most important institution in a country which practices the principle of democracy. Politics of Malaysia takes place in the frameworks of a federal representative democratic constitutional monarchy, in which the Yang di-Pertuan Agong is head of state and the Prime Minister of Malaysia is the head of government. Executive power is exercised by the federal government and the 13 state governments. The Parliament of Malaysia, consisting of the Senate and the House of Representatives, held its first meeting on 11 September 1959. In the Federation, the Federal Constitution Ordinance 1957, passed on 27 August 1957 by the Federal Legislative Council of the Federation of Malaya, formed under the Federation of Malaya Agreement 1948. Where the new constitution of the federation as well as Penang and Melaka were given the force of law by ordinance. In each of the Malay states, state enactment, and in Melaka and Penang, resolution of the state legislatures approving and giving force of the law to the federal constitution. The federal constitution was significantly amended when Sabah, Sarawak, and Singapore joined the federation to form Malaysia in 1963. And under Article 8 in the constitution, which is stated about the equality of all persons under the law. Under the Constitution, there is Article 1 to 7, which is separation of power. Malaysia is a country that values the separation of powers between the executive, legislative, and judicial branch. As this provides check and balance against one another, judicial independence is the bedrock of a functioning democracy, and it treats everyone as equal before the eyes of law. The main purpose of separation of power is to control the three branches, which is judicial, executive, and legislative, so that there is no abuse of power and no overlap occurred between these three branches. So the problem statement in this research is there are no more equality between citizen and politician under the law, and politicians in this country are abusing the power for their benefit. So research question is whether the legal system in this country are weak, and also are the politicians in this country are abusing their power. So the research objective is to study the truth or whether or not the executive politicians in this country are invulnerable towards the law. Next is the literature review. According to the Students for Liberty website, it stated that equal treatment under the law is an ancient ideal that is still essential in today's society, where almost every constitution in the world in some form or another accept this essential principle. The basic concept, also known as equality before the law or isonomy, recognizes that all individuals should be treated exactly the same way by the law, and that all persons should be subject to the same rules. Article 7 of the Universal Declaration of Human Rights formalized this basic right as all are equal before the law and are entitled without any discrimination to equal protection of the law. All are entitled to equal protection against any discrimination in violation of this declaration and against any incitement to such discrimination. In the United States, this principle is also enriched in the 14th Amendment of the Constitution, which has been in effect since 1868, and states that no state shall deprive any person of life, liberty, or property without due process of law, nor shall any state deny to any person within its jurisdiction the equal protection of the laws. However, in practice, the application of this notion is frequently challenging. There might be a misunderstanding between equal rights and equal chances. Government can exploit the appearance of equal chance to impose restrictive legislation that restrict the individual's freedom and effectively denies equal treatment under the law, such as when affirmative action programs are implemented. The possibility of unscrupulous leaders to exploit their position of power is an exceedingly hazardous consequences of ignoring this concept. As a result, it is critical that the law be applied fairly to all persons regardless of their position. There should be no exception to the legislation for political officials, diplomat, police enforcement, legal professionals, leading corporation, or other prominent individuals. In the measure constitutional under Article 8, it stated that everyone is equal under the law, which it means even the politician is also under law and can be charged under any legal offense that they committed. Fourth, separation of power by Charles Louis de Seconded Baron de la Bretette de Montesquieu, an 18th century French social and political philosopher, invented the first trias politica, or separation of powers. His book, Spirits of the Laws, is regarded as one of the major works in history of political philosophy and jurisprudence, and it influenced the Declaration of Rights of Man and the United States Constitution. According to his concept, the state's political authority is split into legislative, executive, and judicial authorities. He contended that in order to most effectively support liberty, these three authorities must be distinct and work independently. Thus, separation of power refers to the division of government tasks into different parts in order to prevent any one department from performing the fundamental activities of another. The goal is to prevent power concentration and to create check and balance. Under the doctrine of separation of power, the government is divided into three branches, namely the legislative, executive, and judiciary. These branches have different roles but are independent with each other. For example, judges are appointed by the chief executive, while laws originate from the legislative branch and will be used by the judiciary to make decisions, while the executive will enforce those laws. This doctrine is also reinforced by the element of check and balance, that each branch has limited power and can check and limit the power of other branch. Thus, a judge even appointed by the chief executive can impose legal punishment on the chief executive because the judiciary has judicial independence and judges are protected by judicial immunity. If this element absent, then the division of power is merely a name. The doctrine of division of power can be illustrated in the United States. At the United States, each branch checks others' abuse of power. In fact, each branch has its own check and balance elements. For example, the police can be interrogated by one independent body or another. And also, in addition, the legislature in most countries is bicameral. For example, in Malaysia, which has two chambers, namely the Dewan Rakyat and Dewan Negara. These two chambers are important to ensure check and balance are implemented in the enactment of legislation. So this doctrine of separation of power requires the executive body to govern the country in accordance with laws that have been passed by the parliament. If the act of the executive body is contrary to the law, the court has the power to declare it void. If the law passed by the parliament is considered ultra-vires or exceed the limit of power allowed by the constitution, the court also has the right to declare the law as invalid and void because it is unconstitutional. In Malaysia, the judiciary and the legislature have the freedom to act in accordance with the provision of the federal constitution. Parliament and the State Assembly are not allowed to dispute actions taken by judge in court. The conduct of a judge shall also not be discussed in any House of Parliament except by standing motion, and notice thereof has been given by at least 1/4 the total number of members of the council. It also cannot be discussed in the State Legislative Assembly. On the other hand, the courts do not have the powers to determine government policies because court judges cannot interfere in political matters. Judges also cannot be appointed from among politicians. The judge's duty is only to interpret the law and not to enact the law. The judiciary is very important to be separated from the political body to avoid abuse of power. This independence of the judiciary is also the dividing line that distinguishes between a democratic government and a totalitarian government. The main role of the court is to guarantee and preserve the rights of the people of a country. Therefore, the court must consist of judges who are competent, independent in their thinking, and firm in sentencing. It can directly be concluded that the most important feature in the doctrine of separation of power is the independence of the judiciary, which is also the main attributes in the federal constitution. Right? How to, The methodology. Okay. The methodology used to discover and analyze material obtained in order to verify the validity that may be used to achieve our aim is known as research methodology. Research philosophy, on the other hand, is a belief about how knowledge on a topic should be gathered, analyzed, and used. The word epistemology refers to what is recognized to be valid, but doxology refers to what is considered to be authentic, which encompasses the many approaches of philosophies of research. There are four types of research philosophy, in which positivist, pragmatist, interpretivist, and realistic research philosophy. Since my research method is interviews, by that our research philosophy is interpretivism, also known as interpretivist, which is the research philosophy. Research philosophy is a research that is based on the principle where social reality and knowledge is subjective, that shaped by human experience and social context, meaning that the key of interpretivist research philosophy is the study of phenomena in their natural environment. Example of research method under the predicament of interpretivist is case studies, interviews, and observation. Interpretivism research philosophy is a synonymously with qualitative research, which is qualitative research is a process of obtaining and identifying a non-numerical data, or could be referred as descriptive data, such as interviews, in order to understand the experience and concept of our target audience for a particular topic. On the other word, quantitative research method focus on describing individual experience with open-minded question. The reason why I choose interpretivism is because I believe external social force affect my study such as much as facts, and because I want to acquire deep understanding on my study from knowledgeable and experienced individuals. And lastly is to choose qualitative research method as my study. Semi-structured interview as the method. Semi-structured interviews are those in-depth interviews where subjects have to answer open-ended, predetermined questions, and are thus commonly used in the study by numerous professionals. Semi-structured in-depth interviews are commonly used as a model for interview with a person, or often even a group. These kind of interviews are done only once with a person or with a group, and normally last from 30 minutes to more than an hour. Semi-structured interviews are based on a semi-structured interview document, a visual presentation of question of subject that the interviewer want to discuss. And also the interview guides have the valuable function of efficiently and comprehensively exploring multiple respondents to achieve maximum use of interview time, as well as keeping the interview focused on the intended course of action. The question is the interview guide include the main question and several similar questions related to the question, which are further improved by the interviews guide pilot testing. The recording of the interviews is considered an acceptable option, but often a matter of contention between the interviewer and the subject in order to get interview data collected more efficiently. So during the interview, handwritten notes are relatively inaccurate, and certain key points can be overlooked by the interviewer. Why I choose interview as the method is because I believe it is the most effective method for qualitative research. By this method, I get to properly extract information from my target of people who I believe would be able to guide me to be a better quality of information and explanation. Secondly, the opinion that it helps me to explore and understand and explain my topic of research comprehensively. This is because as I interview the people of my target, I get to dive into the environment of my interviewee, making me more understanding of the whole experience around the research environment. Thirdly, I feel that open-ended question that goes with semi-structured interview will be able to assist me to gain in-depth information on the study. This is an advantage, as the interview will have control over the topic question, and even the order of question. What data do I collect? The data that I collect are relevant news, cases, and statistics regarding on the justice between normal citizen and the executive politician in Malaysia, and also to hear personal opinions and suggestions regarding the justice problem. So there are 8 questions. So my first question for 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 the interview is, do you know the difference between politician and a normal citizen? Next is, do you think that our country law is strict? That is, do you think that all the people in this country should be treated equally towards the law? 4 is, do you think that the politician in this country should have a special pass towards the law? Number 5 is, do you think that the politician in this country can get away from their legal offense easily? Number 6 is, do you think that the politician in this country is abusing their power? And number 7, do you think that there is a problem in our legal constitution? Number 8 is, what are your opinion and suggestions towards the problem on the equality between the politician and normal citizen? Okay. Who do I interview? The group of people that I think suits best as my interviewees are a normal citizen and also law student, because they know about law. How will the data collected? The first step in gathering data for the study is contacting potential interviewees and scheduling an appointment with them. What I will do is I contact the target interviewees and inquire about the procedures for conducting an interview with the target. Then draft an official letter of inquiry to those target. The aim of this interview, specifics of the study subject question to ask during the interview, and who I want to interview will be included in the letters of inquiry that I will send. After successfully submitted such letter or message, I will wait for a response from the target and act accordingly. The second step will be to draft a list of questions to be asked of the target interviewers. All of the questions will be open-ended, allowing me to glean information from the response of my target interviews. I will also offer semi-structured questions to allow for the emergence of fresh ideas, and additional spontaneous questions may be asked throughout the interviews. Hopefully, this response and new question posed during the interview will allow me to collect enough data to aid in this research. The final step in data collecting is conducting research interviews. During the interview, I'll be using a phone and a laptop, one to record the interview, and the other to capture the audio of the interview. When all the materials are in place, I will begin the interview with pleasantries and introductory question before moving on to the questionnaires. I will allow the interviewees enough room to answer the question comfortably. We are also ensuring that the interview provides me with all the answers I require for this research. Then I will go back and examine the interview video after all questions has been asked and answered. How will I analyze data? I will do a qualitative data analysis to analyze the information obtained from the interview. After that, I will thoroughly review the transcript of the interview. Next, I will collect pertinent material from the interview and include it into my research, and I shall disregard any extraneous material from the interview. Finally, once I have done my study, I will draw numerous inference based on the findings. The analysis finding will reveal whether or not my interviews aided to this research. Next is I will talk about my next is I will talk about my research analysis, which is the first research question is whether the legal system in this country are weak. According to article Perception of Our Justice System by M. Vira Pandian, where the author's opinion is the author explained about our country legal system and also exposed the decision making process of the judges are highly influenced by variables such as severity of a crime, prior conviction, and there are also many extra legal variables that are influential in the process, including age, gender, education, and the political affiliation of the offender. In my opinion, our country legal system is already perfect and well made, but the problem is the people in the legal system. If the people in the legal system or in charge use their power with full trust, I believe that there will be no problem with our legal system. Second research question is, are the politicians in this country abusing their power? In case one is which is March 23rd, 2018, where Labuan members of parliament charged with abuse of power. In case number two is Mr. Najib Razak, who was sentenced to up to 12 years in prison and faces fines of nearly 50 million over 50 million on charge of abuse of power, breach of trust, and money laundering. Article 1, corruption, abuse of power must never be allowed to regain again by Bernama. The author's opinion is to mention that there were clearly an abuse of power and corruption among politicians in this country since a long time ago. Second article is comment, democracy is shackling in Malaysia by Prabak Foran. The author's opinion is the author explained that even during the COVID-19 outbreak, the coalition in this country are still abusing their power and using the pandemic as a justification to grant themselves special powers beyond what is reasonably necessary to protect public health. In my opinion, these country politicians are abusing their power without feeling guilty because they have been doing this since a long time ago and getting comfortable in anything that they are doing because they can always use their power to get away. I think that there should be no overlap occurred between the legal system or any legal authorities with the politician. Okay. Lastly, the conclusion that this research paper has provided all overview in justice in Malaysia, and it explained what are the power of the executive in Malaysia. The previous party or the previous government or the previous people in charge in draft had drafted the constitution well and thoroughly for the constitution. And the rule of law in this country have shown that no individual is above the rule of law. And all the people in this country, not just the citizen, but also the executive, including the politician, are treated equally under the law. But it seems nowadays that some politicians have abused their power for their benefit and also for their own political benefit, political party benefit, and they use their power to hide all the legal offense that they have done using their power. So my suggestion is the legal justice in this country need to be improved more and strength to ensure the integrity and stability of the rule of law in the country to be more efficiently. And also, the people in this country should pick the right party politics to govern this country because in the previous government, as you can see, there are many corruption have occurred and there are many abuse of power occurred during previous party politics that govern our country. So there are my suggestion that should be the country, the justice in this country need to be improved and strengthened more to ensure the integrity and stability of the rule of law in the country to be more efficiently. And next limitation during this research is some article or website need to be paid to view or behind paywall that I need to pay to view the article. Second is the topic is sensitive and some of citizens are afraid to get interviewed and to give their own opinion. Some people that I approach don't want to give their opinion and don't want to be get interviewed by me because they are afraid of this topic. Okay. Lastly, is some news or article has been removed by the government. Some news, there are many news and article that has been removed by the government because the news and article, even though it is true, but they 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 clearly is abusing their power to hide the news from people because they're afraid that the news or article will give a very image of their party politics. That is all for me. Thank you for your time. Assalamualaikum.